law requires. Thank you.
Take questions.
I'll take questions.
Representative Anderson is recognized for question.
Thank you, Mr. Speaker. Representative Fry, certainly we thank you for your explanation to this bill. And this bill is much needed, and I hope everyone would vote for it because we do have a serious problem on the coastline. Thank you again. Appreciate the hard work.
Mr. Hill is recognized for question.
Thank you, Mr. Speaker. Mr. Fry, appreciate your entertaining questions here. My question is, what is the evidentiary standard required in order to keep the contest? If you're, I'm struggling with terminology here, but you understand what I'm saying. If I want to contest a permit, I have that 90 days to do that, and then there's a hearing within 30 days of that action, and then then it goes away after that unless I prove certain things that are laid out in the bill. Now, what evidentiary standard is required for me to prove those things?
You have to prove, much like an injunction standard, you've got to prove that you have a likelihood of success on the merits. You've got to prove that there would be irreparable harm to the environment or whatever you're trying to do. So those burdens are on you. Right now, if I'm a permit holder, Mr. Hill, the burden is on me to prove why I was given the permit to begin with. But in any lawsuit that you file against me or that anybody files against somebody else, the burden is always on that person who's filing the lawsuit. And I think that's really where we get back to a balance. When you look at kind of what other states do, the burden should be on the person challenging the permit, and I think that's where we go to. But much like an injunction standard, if you're going to stop that, you go through, you have to prove why it would cause irreparable harm. You have to show that you have a likelihood of success on the merits, things like that you would show to the judge.
So the maximum time that can elapse would be from if day 1 is when the permit is requested, day 90 is when someone contests that, day 120 would be the maximum date for when that initial hearing could be held. Is that correct? Am I understanding the timeline correctly?
And I think if I understand, let me explain. If I'm wrong on this, you tell me, but you get all your permits on the front end. When you get all those, that's where you file your lawsuit. And so at this particular point, when you file that lawsuit, if you filed it against me as a developer, I can move to lift that stay, okay? The stay stays in effect automatically for 90 days. At the end of 90 days, I can move to lift that stay. There's a hearing under the bill within 30 days, so you're at 120. And then at that particular point, you look at, you give it up to a judge to decide, to weigh the merits. And I think that's really where we go about this is, currently, if I just challenge something today, I don't have to prove anything until a judge decides to hear the case. So this allows 90 days for the stay to stay in effect, which is in line with other states. Some states don't have a stay. And then I get in front of a judge to let them kind of weigh the merits of the argument. And I think what we've seen, not only is it the stay that is used, but sometimes it's the threat of the stay. If I'm a business owner, I'm looking at getting out as quick as I can, and I'm willing to cave however I need to because I know that I'm going to be held up in court for years on end. So I think this gets you in front of a judge.
Right, and I understand that. So once you're in front of the judge, you make your case, how long can the proceedings last? I mean, is that your one shot, that one hearing, is that your one shot and then the decision is rendered?
No, sir. I think that the bill calls for all cases to be wrapped up within a year. But the judge could certainly continue the pause. All the stay is a pause. And so if the judge didn't have enough evidence, wasn't sure, he could certainly continue that. But again, it gives him that discretion to do that because right now we don't give him that discretion.
Thank you.
Ms. Brawley is recognized for a question.
Just so that I understand, the judge that you're referencing, is that the administrative law court judge, or are we talking about a circuit court judge? Because typically, those kinds of cases go first before the administrative law court judge.
You are correct.
Which may or may not be within that window of 90 days. So if the administrative law court judge rules and my 90 days have not expired, have I exhausted all my opportunity for appeal?
Well, the 90 days is automatic. So right now under the current Senate bill, 90 days, I can't file a thing. You can't file a thing. It just stays in effect. At the end of 90 days, the stay could either continue if I filed nothing, or if I asked for the stay to be lifted, at that point, a judge would hear the arguments on both sides, whether or not. So we certainly have a pause for 90 days. We certainly have a pause for that 30-day period where the judge is hearing it and gives him time to make a decision. But it doesn't affect that 90 days at all. I can't do anything, and no one can do anything for 90 days. It pauses everything until, and then if I'm the aggrieved party, I make the determination whether I'm going to ask the judge or the court, the ALC, to lift the stay or not.
But I guess what I'm trying to determine, does the administrative law court judge's decision terminate my ability as a private citizen to move to another level of appeal?
No, it does not terminate your rights to appeal at all. It just helps finalize the process within the ALC a little bit more quickly.
So you still, a private citizen can still continue on through the court system beyond ALC?
Yeah, there's appellate rights and things like that to the Court of Appeals, absolutely.
And would the stay be impacted if a private citizen is in that position?
Could. It depends on the judge for sure, but I think the biggest thing is that usually pending this, you got to put up bonds and things like that, but I think that's where when you have a decision from an ALC judge, they can either choose to continue with wrapping up the case. I mean, and let's take it two scenarios. If the stay continues, the stay continues. The judge may say, look, I'm not sold on this yet. We're going to continue the pause right now, and then we're going to come back here in 30, 60, 90 days, whenever the judge says. All this bill says is that all ALC cases have to be wrapped up in a year, but it certainly continues to preserve your right to appeal however you feel like you need to appeal.
And again, if I exercise that right to appeal after an administrative law court judge makes a decision, what happens to the stay?
Well, it depends on the decision, certainly, but the stay is just a pause. So if the judge says, as an example, that the stay will continue, I don't think that you would not appeal that decision. But if the judge says we're going to lift the stay, you still have the final outcome of the case where the permit holder is on hook and DHEC or anybody else is on hook for any mitigation or damage to property at that particular point. So there are still monetary things that may take place. In addition to that, they have the ability to say you have to put back the property as it stands. That's one outcome that could happen because of this.
Ms. Cobb Hunter is recognized for a question.
Thank you, Mr. Speaker. Mr. Fry, forgive me if somebody has already asked you this question. I'm afraid I've just started focusing in on this. Tell me why we're doing this.
Thank you, Ms. Cobb Hunter. I appreciate that. You know, if you look at instances throughout South Carolina, what we see is not always, it's the stay that is used sometimes that doesn't get in front of a judge in time, that kind of holds up a project for a length of time. And on the front end, too, it's not always the actual use of the stay, it's the threat of the use. And so what we saw in Boeing, as an example, is federal law required Boeing to pay $750,000 in wetlands mitigation credits. That is what they required, and I think that's, was a fair resolution. But in order to avoid a lawsuit, the Coastal Conservation League and others came together with Boeing and the state and said, if you, South Carolina taxpayers, give us $5 million, we will not challenge the project. We will walk away, and we agree to publicly support that. So that was laid out kind of in the LAC report on Boeing. We've also seen that in the port of Charleston, where they publicly agreed to support the deepening of the Charleston Harbor in exchange for $5 million. We've seen it with Boeing. In International Drive in Horry County, that's a local road that the voters voted on, agreed to raise, to tax themselves and to build that road. These folks came forward, and the interesting thing is, this is what I talk about proof and why it's so important to prove something in front of a judge. They challenged a water quality permit in International Drive, but then continued to argue about bears. Well, there's no permit for bears, right? Mm-hmm. There's a permit for water quality, and so the judge pretty quickly dismissed that case. And they continue to lose every other court hearing that they had. So I think that's all why it's so important to get in front of a judge, to let them weigh how meritorious this challenge is.
What does this do to the docket of the administrative law court? What, if anything, what effect will this have on their docket?
I don't think, if anything, it might diminish the dockets themselves because you have less cases being filed. In my opinion, that might be considered frivolous. But two, it does kind of put them under an obligation to wrap up a case within a year, and that would be statutorily mandated.
And if I understand what I'm reading, what this is doing is establishing a time limit, 30 days, as opposed to open-ended for the stay. Is that accurate?
It's the stay would be 90 days under the Senate language. So you would have 90 days where you could do nothing, and then at that point, if you chose to exercise your right to file a motion to lift the stay, you could, but you certainly don't have to.
how would you respond to those who feel that this bill may have a negative impact on someone's ability to try to fight big government?
I don't know that it fights big government as much as it fights,
Well, and let me rephrase it, if I may, Mr. Fry. How would you respond to people who see the stay and either granting a stay or lifting a stay as an opportunity, as one of the tools in their toolkit, shall we say, when we're talking about environmental issues and wetlands, for example? How would you respond to people who feel that maybe what we're doing here unintentionally is impacting one's ability to fight against big government? And I said big government, but let's just say the big guys.
I don't think that it limits it at all. I think it actually gets you in front of, if you have a meritorious challenge, it actually gets you in front of a judge more quickly. And this is important. If you look at other states around the country, some states don't even have a stay. They say that if you file a challenge, it doesn't automatically give you a stay. You actually have to file an injunction. Some states say that there's a stay until such time as a judge hears it. North Carolina, interestingly enough, back in 2013, removed their permitting stay on coastal zone management permits. And when that happened, there was testimony in the LAC report itself on our end that they said that hasn't impacted them at all on those particular permits. So some would argue that you don't even need the challenge, that you don't even need the stay. You get in front of a judge as quick as you can. But for purposes of this, what I think this does, Ms. Cobb-Hunter, is it restores a balance.
Okay.
And so if people are being disingenuous or not acting in good faith, it gets them in front of a judge to make a decision more quickly.
Just one thing, would you agree that there are some who were a part of the mediation and arbitration in those two projects you mentioned, who would characterize it a bit differently than you did as far as grabbing five? I mean, just the way you framed that. I think it's important for the body to know that your characterization of what happened in those two projects, both with Boeing and with the port, that those people who were intimately involved might have a different characterization than what was shared from the podium.
Well, they certainly have a difference of opinion, but I think the LAC report speaks pretty well to this on the fact that we gave almost 10 times as much money to them as required by the federal government. There was no accountability for the interest, so that didn't return to the taxpayers. They kept that. They were not provided detailed invoices, and when the LAC actually asked for, how did you value this land, they could not produce that. So I think this brings back into account protecting the taxpayers and also, in good faith, getting in front of a judge. If you've got a good argument, the judge is going to hear that. You still have your appellate rights. It preserves the stay, which I think is important, but it gets back to a balancing act so that we're not in court delaying necessary projects like the Port of Charleston for years on end.
Thank you, Mr. Fry. Thank you,
Ms.
Mr. Speaker.
Mr. Robert Williams with a question.
Thank you, Mr. Speaker. Representative Fry, certainly you're doing great job there. I understand that based on this, it says the court shall lift the stay for good cause shown. How would you determine what is good cause? What is your definition? Or maybe because help me to understand what is good cause, and help me to understand what is irreparable harm.
Good cause is somewhat of a subjective standard, but I think we also set forth in there that things you have to prove, irreparable harm, things like that, to the environment if this project were to go forward. So it is up to the judge to look at that. And if you look at prior court orders from the ALC on things like this, they weigh depositions, they weigh testimony. Say International Drive again. They challenge.
Mr. Speaker, can I get a little?
House will be in order.
Thank you.
They challenged a water quality permit, but then they argued about bears, and that was the whole fight, was about bears, right? So in that case, the case was dispensed with rather quickly, but I think that's where the judge comes in and through their training is able to kind of weigh the factors, look at the standards that we set forth in this statute and make a determination.
Okay, so it's going to be totally up to the judge to weigh the factors to determine what is good cause.
Correct, based on the evidence that you have to prove as somebody challenging the permit.
And likewise for the irreparable harm.
Correct.
Okay, thank you.
Pending question.